From the Colorado Supreme Court, it disqualifies President Donald Trump from the state's primary ballot. But the issue is far from being settled. Trump's team will likely appeal. His name will remain on the ballot if the decision is appealed to the U.S. Supreme Court by January 4th. So we continue our conversation and coverage of this now with Jessica Smith. She's a constitutional law expert and a partner at Holland and Hart in Denver. This is incredibly complicated for people to understand.
There's so much to, if you had to tell, because I'm still trying to, Marshall helps us. What is it we're not understanding about this? This was, I mean, we've heard this in other states. What are we not getting about this suit and this decision?
Great question. So here we have a lot of different legal questions that were all answered. And I think what people are wondering is, to what extent does this lawsuit implicate the elections in other states?
Right.
What portions of this opinion from the Colorado Supreme Court can actually be appealed to the U.S. Supreme Court? What portions of the opinion are settled? What's done? And those are all different important questions. And the real sum of it is that this is limited to Colorado. This was a question in most respects of what was allowed under Colorado's election code. Now, of course, there were questions answered related to the 14th Amendment and Section 3 and whether or not former President Trump engaged in insurrection. Those are questions that are likely to be asked in other states, but what the Colorado Supreme Court says about those questions only matters in Colorado. It's not binding in any other state right now.
Marshall ended his piece with an interesting question about the parties in this case. A lot of them were interveners. Like the Trump campaign itself is an intervener in this case because it was originally a suit between the group that filed the lawsuit and Jenna Griswold. So how can these interveners, like the Trump campaign, appeal to the Supreme Court?
Our Colorado Rules of Civil Procedure set up a process by which anybody who is not a party to a lawsuit can do what is called move to intervene in a lawsuit. That means filing a motion with the district court saying, I have an interest in the outcome of this lawsuit. Let me appear, participate in the proceedings, that type of thing. That's what happened here. So various parties filed motions to intervene in front of Judge Wallace in the district court. She granted those motions, and then once those motions were granted, for all intents and purposes, those interveners become parties for the life of the lawsuit. They can participate to the Colorado Supreme Court, which we saw, and they can also participate in any potential appeal to the U.S. Supreme Court.
So assuming that's going to happen, which it seems like it is, what issues would the U.S. Supreme Court be considering?
The U.S. Supreme Court is limited to considering issues of federal law. And so here, where we have principles of federalism at play, we have state and federal courts. The U.S. Supreme Court is the decider, the final decider of issues of federal law. But our state Supreme Courts are the final deciders of state law. So to the extent the Colorado Supreme Court answered questions of state law, so for instance, interpreting our election code, the Colorado Supreme Court gets the final say on those issues. However, there are issues of federal law that were implicated and analyzed in the Colorado Supreme Court's opinion. Those can be appealed to the U.S. Supreme Court, and the U.S. Supreme Court has free rein to completely disagree with whatever the Colorado Supreme Court said.
What do you think is the largest piece of federal law here that the Supreme Court could potentially weigh in on?
There are a couple of very big questions. There are some completely unanswered questions where the U.S. Supreme Court has never weighed in. Interpreting Section 3 of the 14th Amendment is one of those. Yeah. So whether or not the president and the presidency falls under Section 3, that's an interpretation of the Constitution. The U.S. Supreme Court hasn't answered that question. There's also some really interesting questions about whether or not the First Amendment protects former President Trump's speech. That's a federal question. There is also the interesting question that kind of runs throughout the entire Colorado Supreme Court opinion, including some of the dissents about whether or not our election code and the expedited procedures in the election code afforded former President Trump sufficient due process for the purposes of his constitutional right to due process.
For people like you, this is great stuff, and is it? You can nerd out and do everything, but the rest of us are just trying to catch up.
But I like getting nerdy, slightly nerdy about this. It's interesting.
There are some really interesting legal questions here, and I think most of the time the folks that pay attention to these legal questions are just us that are interested in them. But what's really important about these issues is that there are real-world consequences. These are things that matter to issues that are foundational to our country. And so I think it's kind of interesting that folks are spending a lot of time with the Constitution and figuring out what Section 3 of the 14th Amendment says.
Yeah, isn't that the little book you're given in middle school? I mean, seriously, look it up.
Yeah, it definitely, that's exactly right.
Thank you so much.
Jessica.
We
Thank you.
appreciate it.